Welcome, Dr. Sarah Deer. Professor Sarah Deer is a citizen of Muskogee Creek Nation of Oklahoma and a university distinguished professor at the University of Kansas. Her award-winning book, The Beginning and End of Rape, Confronting Sexual Violence in Native America, is a culmination of her quarter-of-a-century work with survivors. She led the creation and publication of an Amnesty International report that reframed the problem of sexual violence in Indian country as an international human rights issue. She helped pass two pieces of landmark legislation. The first is the Tribal and Order Act of 2010, and the second is the 2013 reauthorization of VAWA, or the Violence Against Women Act. These began changing federal policies that interfere with the sovereign rights of nations to prosecute non-Native offenders who harm Native women. When Dr. Sarah Deer was last at our coalition conference as a speaker, she also was just notified that she was a MacArthur Foundation Genius Grantee. So we're so happy and honored to have Dr. Sarah Deer with us today. Thank you. Take it away, Dr. Deer.
Thank you so much. Everybody can just call me Sarah. I'm already emotional about the task at hand, and that is to interview a woman that I've never met, but who has had a great deal of influence in my life and my work and the work of so many advocates across the country. I'll start just with a few words in my own language. Hijje silo ijo chaho chifkados, amalegera kitlax, taplako medawados, ahagahaya agadichet mahayados, University of Kansas, adotkados. So I just shared with you a little bit about my identity and my tribal town and the work that I do. I'm really honored to be asked to provide a few remarks today to introduce a woman who I have never met in person, but I know her story and the meaning it has meant to me and many other Native women across the country. Yvonne's case emerged out of an incident that occurred exactly 3 months before I was born in 1972. And as a Native woman in 2020, I look back on this case with gratitude and an acknowledgement that I am a beneficiary of her struggle to survive. Now, the story began in 1972 when Ms. Swan shot and killed a child molester, William Wessler, a white man who stood at 6 foot 10 inches tall. Ms. Swan was forced to defend her family and her children and herself after repeated pleas to the Spokane police for help were ignored. And initially, she pled guilty to the crime, but in her own work to identify attorneys who would understand the dynamics of the case, she withdrew that guilty plea in December of 1972. And she was convicted in May of 1973, but immediately appealed that conviction to the Washington Intermediate Court of Appeal, which issued an opinion just 2 years later, reversing the conviction. The state appealed to the Washington Supreme Court in 1975, and a new brief was filed on her behalf in 1976. And one of the things that strikes me about the story as an attorney, because that's my training, is that she was very proactive in finding qualified attorneys who were willing to take risks in the current political climate in which this case emerged. And one of the most important outcomes of her struggle was to develop what became now, and almost taken for granted, an important argument about gender and self-defense. And the argument made went something along these lines. Society's failure to protect women from male violence should play an important role in defining women's reasonable assessment of danger. And this is important because at the time, the standard approach to self-defense was that it had to be put into the assessment of a man's reasonable assessment of danger. But this, of course, does not address the unique situations that women experience when they are dealing with a dangerous perpetrator who is significantly larger than them, who is significantly more strength, has more strength, physical strength than they do. And the courts had been really focusing on this idea of self-defense from a male standpoint. And nobody had really ever made the argument work in terms of framing it not just as a reasonable man, but a reasonable woman. And so in these efforts, Ms. Swan was not just a defendant, she was an activist. She organized with her sisters the Defense Committee for Yvonne Wanrow. And the ultimate outcome here is not just meaningful to Native women, but also women's issues in general. And the fact that she had women attorneys that she sought out as a part of her team. And even though the term intersectionality had not yet been coined at that time, we can clearly see the intersectional arguments made by the attorneys. And the decision decided by the Supreme Court in January of 1977, almost 4.5 years after the incident, was a 5-3 decision in favor of Ms. Swan. This ruling was the first in the country recognizing the particular legal problems of women who defend themselves and their children from male attackers. Now, the plurality of the court, 4 justices, found that the trial court had failed to properly instruct the jury on the law of self-defense. The legacy of this case is that women charged with killing abusive current or former boyfriends or husbands can use this argument about the reasonableness of the self-defense. And so the case today is now associated with the development of self-defense standards for all kinds of gendered issues. Now, one of my favorite law professors in the country, Donna Coker, wrote an excellent book chapter about this case and its implications. And I highly encourage folks who haven't read it to please do so. It's in a book called Criminal Law Stories that was published in 2013. And in that chapter, Donna Coker remarks on the social significance of this decision, writing, although Wanrow did not defend herself against an intimate abuser, the plurality opinion would ultimately provide a crucial tool for victims of domestic violence who acted to defend themselves against their abusers. And in writing about the legal significance of the decision, Professor Coker writes, however, the case and the activism that surrounded it had an impact that went far beyond the change in self-defense doctrine. Not only did the case open up a new line of argument, but perhaps more importantly, defense attorneys began to understand female homicide defendants differently. Before the case, self-defense was not seen as a viable defense strategy for battered women who killed their abusers. But since the decision, many courts have ruled in the favor of battered women who react in self-defense to the harm that they have been experiencing. But at that time, it was a novel defense. And I think now many of us have taken for granted that this kind of defense is available for battered women who kill their abusers. Another legacy of this case is that it is now taught in law schools across the country, and not just for classes that focus on law and feminism or domestic violence, but in straight criminal law altogether. And when I taught criminal law, I always taught this class. And so to that extent, it is now being used to educate all of the new generation of criminal law attorneys that are coming into practice. Now, I want to say a little bit more about the legacy that we are still working with today. And as Judy had mentioned, I have been working on the Violence Against Women Act for a very, very long time, and trying to improve the act to better meet the needs of Native people who are experiencing violence. Now, although this crime, or the alleged crime, the self-defense, did not involve a reservation, I think that I have learned enough about this case to understand how to work with these issues as they arise on Indian reservations, particularly in the case of non-Indian perpetrators. Now, during the same time that Ms. Swan was fighting for her justice, the Supreme Court issued a devastating ruling, again arising out of Washington state, in the case of Oliphant versus Suquamish Indian tribe. And in that case, the Supreme Court ruled that tribal nations had lost the ability to prosecute non-Indians for any crime that they committed on the reservation, including murder, child sexual abuse, rape, and domestic violence. And that case was good law until 2013, when many of us were able to convince Congress that tribal nations should have the authority to prosecute non-Indian offenders of domestic violence. Now, the statistics around this issue continue to be alarming. And that is that over 90% of Native women report that they have been victimized by at least one non-Indian perpetrator. And to the extent that these crimes are happening on Indian reservations, the tribal nations are unable to assert jurisdiction in these cases. But in VAWA 2013, we were able to capture an exception to that general rule for issues of domestic violence. And today, there are many tribes that have taken advantage of this change in the law to prosecute non-Indians who commit crimes on the reservation against their Native partners or former partners. Now, there's still a lot of work yet ahead of us because tribal nations still lack jurisdiction over non-Indians who commit other crimes outside of the context of domestic violence. And I'm really proud to be part of the movement to continue to address Oliphant through the Violence Against Women Act. And the pending legislation right now is to allow tribal nations once again to prosecute non-Indians who commit acts of child sexual abuse, rape, and assault on tribal police officers to the list of crimes that tribal nations can prosecute. So even though Ms. Swan's case did not occur on an Indian reservation, the legacy of the need to protect Native people from non-Indians continues. Now, in terms of the jury issue, because one of the struggles in this case was to address the anti-Indian racism and anti-Indian sentiment of this time period in the 1970s. But this is an issue that hasn't gone away. And so the fact today that most federal juries prosecuting or sitting in judgment of Native people still lack Native representation. And so we are still living with the challenge of addressing the fairness in criminal court for Native defendants. The other issue in this case was whether or not Ms. Swan's Native identity should be articulated in a way to help the jury understand the circumstances in which she found herself. I've testified in several trials in the state of Minnesota on behalf of the prosecution for victims of on behalf of victims of crime that behaved in ways that seemed counterintuitive to the jury. There was a case just a few years ago where a Native woman had been sexually assaulted, but she did not immediately flee the scene after the assault occurred. And that was being used against her. In other words, that if she had truly been the victim of assault, that once the assault ended, that she would flee from the scene. And despite the fact that my expertise lies in the dynamics that Native victims of violence experience, the court would not allow me to testify about how a Native woman who has been sexually assaulted might experience the crime and why she might make the decision in terms of self-preservation to not flee the scene immediately after the incident occurred. So there's still a long way to go, right? So we still have some of these challenges. But I think in this day and age, many of us take for granted that there are special self-defense rules that acknowledge the situation in which women find themselves when dealing with an abuser. Professor Donna Coker, again, in her fascinating book chapter about this case, wrote that this case and Ms. Swan became a powerful means of putting feminist theory into action to fight gender bias in the criminal justice system and marked the beginning of what came to be called women's self-defense work. And that is the legacy that we honor today. And so for me, as someone who was coming of age long after this decision came down, I am so thrilled to be able to offer these remarks and to again reiterate how important it has been for me as a Native woman and as an attorney to learn from this case and share this case with the next generation of law students and lawyers coming out of law school. So I cannot say enough about how much this means to me to have this moment and to be able to share part of this story with you. There's much more to say about her. There's many more things she has accomplished outside of this case. But that's how I want to honor you today. And thank you as a woman born in 1972 for the work that you have done to make Native women safer in this country.
Thank you so much, Dr. Sarah Deer, for that incredible talk about this amazing person. We are very honored to be able to present the first ever WSCADV North Star Award to Ms. Yvonne L. Swan. This recognizes a Washingtonian whose life, courage, and impact can act as a North Star for our movement. The WSCADV theory of change, which we've shared with you over the past few years, sets a pathway for the future that we all want and need, a culture and a place where all people can live and love freely without fear, where beloved community, personal sovereignty, and interdependence are what we can all have. The North Star Award is new for us, and it honors a person who leads by example to create this future for us. Ms. Yvonne L. Swan's life and struggle are an example of this, connecting the past with our present challenges in today's society for fairness and justice for all, and setting forth an example of restoration, healing, and making a good life.
In my language, I like to greet you. Why is Naxil? Luton Cha American, Luton Cha Canadian, in Cha Constant Eichst. Hello, my relatives, my sisters, my brothers. I am Ipat, my grandfather named me, but my English name, French name, Yvonne. I am from my mother's lineage. I am St. Eichst, Arrow Lakes. From my father, I am Ojibwa Cree and Assiniboine Sioux and Coeur d'Alene. So I just want to introduce my mother. This blanket means a lot to me. It was a gift from my sister, the eldest in the family of the girls, who's now passed on, but she and her husband gave that to me. I don't know if she knew, but my mother's name, her Indian name was Kempt Pizza. And I asked Mom, what does that mean? And she said, well, that means shining blanket in the distance. Oh. And she said there was a lady that was wearing a striped shawl. And when she was walking across the way in the distance, the way the sun hit it, it made it look like it was shining. So I like to take my mother everywhere I go if I can. I see in the picture I'm wearing them. My father is also with me because my dad was a boxer, and he taught this man how to box when this man was a child on the Coeur d'Alene Reservation in Idaho. Carl Maxey, who was a well-known criminal lawyer in Spokane. He was a family friend, and I loved him very much. I thank you, all of you on this coalition, for inviting me. I thank my friend Kathy Richards for putting my name in. She knew what to do, I guess, because I was very honored and expected. I mean, I was ready. I'm always ready to share whatever people want to hear. It overwhelms me what I went through because it took almost 12 years, but at the time I just kept going. I didn't even think about the time. My dad was a boxer, but he never taught me how to box. But I knew how to defend myself. I was always having to do that. I was a victim and the victor, or whatever you want to call the winner. But when I got in trouble, the main thing was my children. And it's still like that today, like any mother would protect her children. I learned a lot as I went through trial. I really believed in justice. I thought the jury will understand my predicament, how scared I was, how terrified I was of that child molester. In my eyes, anybody who will abuse a child, a defenseless child, like he did, was capable of anything. And even after I was convicted on Mother's Day in 1973, I still kept fighting. I told my sisters, we got to do something or else they will put me in prison and take my children away from me. So the more I thought about it, the more I wanted to fight. I wanted to defend myself in the court system for my kids, for my family. I don't regret a minute of it. And to hear that the wonderful words that Sarah said and that Teresa said, that Judy and Max, all of you, Donna, all of you, just makes me so happy. I really am honored. I am humbled. In a word, one time somebody asked me, what made you keep going? I said, in a word, it was stubbornness. I was stubborn. This one man told me, he said, Wanrow, Wanrow, he was a Sioux. He said, I'll name you one road, Rosebud Wanrow. And he looked at my boyfriend, Floyd, and he said, she's got one road. I didn't know what he meant, but he was a visionary. He saw that I had something to do. So now I'm back with my children, my grandchildren, my great-grandchildren. And it makes me feel good when they stand up to themselves and they say, not guilty. I wanted a good lawyer. I had a good lawyer, but I wanted somebody that was sensitive to Native issues. I was active. My eyes were opened when I met the feminist movement. My eyes were opened when I met the American Indian movement. It was like I found a family. I found support. So I got William Kunstler because I saw him in action in Minnesota, defending the Wounded Knee trials. When I went to New York, I wanted to meet him, and I was introduced to him, and he read my papers and he said, Yvonne, I'll take your case, but I see some feminist issues in here, and I want to take it to the women attorneys in the Center for Constitutional Rights. And that's how I got the lawyers. And every time I went to American Indian Movement meetings, I went to spiritual meetings, ceremonies, I got stronger and stronger and stronger. No fear when I went into the court the last time. I was optimistic. I knew, I felt all of your energy, all the prayers, and I feel it now. Thank you for your help. I really love you.